All right, good afternoon, everyone. My name is Joel Hyatt, and Kara Murphy and I are the co-chairs of the General Civil and Business Litigation section of the Lee County Bar Association. I'm sure some people are still trickling in, but thank you all for coming to today's presentation, which is the best practices for non-binding arbitration. Good news, we're approved for CLE. Lauren Baugh, our trustee executive director of the Lee County Bar Association, is taking attendance. So everyone here today gets their CLE credit. And just so everyone knows, this session is being recorded and posted to the Lee County Bar Association's YouTube page so that people can go ahead and watch it again in the future. If you missed our September presentation on utilizing a private judge under section 44401, I highly recommend that you go back and check that out. For better or for worse, non-binding arbitration is here to stay in Lee County. And today we've got some of the top local arbitrators here to discuss the best practices that we can all use in arbitration.
So we've asked both George Knott, Steve Blount, and Berk Edwards to be our panel today. And if you don't know who these gentlemen are, you should. I know the courts have put them on the orders now. I'm seeing orders coming in specifically designating one of the three of them if the parties cannot agree. I can tell you that in almost every single non-binding arbitration request that I've had with opposing counsel lately, one of the three of their names, if not all three of their names, are being passed around. And that's compliments to them because of the not only the volume of work that they're getting, but the quality of their orders and their handling of non-binding arbitrations. So Joel and I thought it would be best that we ask them to give us some pointers and practice tips on how this process has been going since we rolled out the non-binding arbitration requirements over the last several years. So starting that, I'm going to ask a few questions related to just the generalized nature of scheduling the non-binding arbitrations. I know every judge has been doing this differently. Just from experience, I know Judge Kyle and Judge Laboda have been issuing orders that are a little earlier in the case. Judge McHugh has taken the position that you do not have to do non-binding arbitration and mediation. So we're getting a mixed bag on some of the judges. I know Judge Foster and Judge Brody are a little bit different with their rulings as well in the 20th. So I guess my first question that I would pose to the panel is, are you seeing that the parties are finishing discovery and finishing all of the requirements with respect to designations of experts before they hit the non-binding arbitration process? Or are you finding that people are still navigating through the discovery process and almost using the non-binding arbitration as a discovery tool in and of itself?
Want me to give it a crack, Kara?
Sure, go ahead, Berk.
Sure. Folks, good afternoon. I certainly recognize the vast majority of the names here on the on my screen. So, Kara, as to your question, I guess typically the vast majority of the arbitrations I'm handling, I would say that discovery is certainly well on its way. It is probably for the most part not been finalized, but what I would call the important parts of discovery, key witness depositions, party depositions, expert exchanges, and/or opinions have probably been completed. I would say that the minority of the cases that I'm handling for arbitrations, all discovery has been completed. And I would also say the minority of the arbitrations I'm handling, very little discovery has been completed. And I tend to find, and Steve and George can probably weigh in too, that when discovery has not been completed to somewhat of a substantive degree where the parties can exchange a meaningful dialogue, provide the arbitrator with some evidentiary materials and not just proffers based on unknown witnesses or stuff that's not been, met in the record. I'm finding either requests for continuances, motions for continuance, a cancellation. So yes, I think for the best part, the vast majority of the substantive discovery has been undertaken before these are really brought before me.
Go ahead, George.
tend to agree with Berk. Most of the arbitrations that I handle are late stage arbitrations, not early arbitrations. And I think arbitration, although there's some, I guess, some commentary out there that might suggest otherwise, I think arbitration is a process that's better left to later stages of a dispute as opposed to the early stages. Unlike mediation, I think mediation, although many times it's not successful at early stages, I think it can be an effective tool. I don't believe that's the case with arbitration, but I will defer to Mr. Blount or Mr. Edwards as to whether they disagree or agree.
I think without a doubt, the vast majority of discovery needs to be done prior to arbitration. You just can't adequately present a case when you're both putting up surprises and claiming, certain witnesses are going to say certain things that have never been deposed and so on and so forth. And I do get a lot of scheduled arbitrations that are scheduled per court order early on, and then the parties are moving to continue them. Maybe 2 weeks, 3 weeks beforehand, they're trying to stipulate to a continuance because they're not done with discovery, and the attorneys recognize they need to be nearly done. I mean, like Berk said, the key players, the key discovery needs to be done. It's just not effective without it.
So I recognize that the process is loose. It's intended to be loose via proffers and no live witnesses and things to that nature. And I know that some of the judges are split in their position on when they go to non-binding arbitration. So I'll give you an example. I was in front of Judge Kyle recently, who stated that he will not allow new witnesses or new experts that were not presented at the non-binding arbitration. And so that poses an interesting thought process on the timing of scheduling, because you can't have it too early if he's going to stand by that position or implement that rule, because you can't certainly know all of your witnesses unless discovery is completed, but yet it is still a loose and informal process. So I guess it's the collective panel's discussion that really most of the majority of the witnesses need to be finished before you get into the non-binding arbitration process, and especially experts. Is that what we're generally hearing then?
Correct.
Making it just too difficult to otherwise render a fair decision as to what the outcome is going to be, which also poses interesting discussions as to a trial de novo, which I know Joel is going to get into in a minute, because you're essentially starting a new case all over again if you're just starting to get witnesses and experts after the non-binding arbitration. So I think the collective best practices would be to try and schedule it as late in the process as possible after completion of the discovery deadlines, but perhaps maybe 3 or 4 months before trial, so everybody's kind of more solidified in their positions. That's best practices.
Well, and that actually goes into, what the proffer is. I don't know if George and Berk are having this experience, but I certainly have the experience where people come in and you have a pre-arbitration conference and you discuss the proffer and everything. But when the day of the arbitration comes, rather than get a proffer, you get a 90-minute argument. And it's important that the counsel be prepared to make a proffer. I'm going to call this witness. That's what this witness is going to say. Not just saying, well, let me tell you what happened. What happened was this guy, it's not a proffer to just get up and try to describe what happened. You need to say, I'm going to proffer these specific exhibits. I'm going to proffer these witnesses. Because, for instance, in the circumstance with Judge Kyle, if you come in and just say, this is what all of the witnesses will say, well, how's Judge Kyle going to limit his witnesses after that? Because you didn't say who you're going to call and what exactly each witness is going to say. And so it's important that you get that on the record, particularly if that's the way Judge Kyle is ruling.
So that's actually a really good segue, Steve. I do see 1 or 2 young lawyers on here that might not be as familiar with the arbitration process. So I guess I would ask a 2-part question. First, what is a proffer, and what are the best practices for actually proffering in a non-binding arbitration?
Well, like I said, in my opinion, the best way to do it is if you have your exhibits forwarded to the opposing party and the arbitrator early before the arbitration, and you walk through the exhibits and discuss how the exhibits are going to come in and what witnesses are going to be called. And you don't have to, as the thing progresses, it becomes more and more obvious, but early on, it's important for you to say, these are the facts that are going to come from this witness, and these are the facts that are going to come from that witness. And this is what, or even proffering deposition testimony, and sometimes it's important to read it into the record specifically rather than summarizing it. And I know for me, if you summarize it, I'm going to want to know the book and, you know, the page and line number where that testimony exists, because I want to go read it and see if it was summarized accurately. I don't know if George and Berk are having the same experience, but oftentimes you'll have an attorney that starts proffering, but about halfway through it just becomes he's telling a story. And that's very difficult to follow and very difficult to rule on when it's presented that way.
The form of the proffer, I would tend to agree with Steve. One thing I think is a little bit different. I take the statute and the rule literally. And if you read the statute and the rule, it says the hearing shall be conducted informally. Presentation of testimony and evidence shall be kept to a minimum. So as far as tying testimony to the record, I don't do that. Okay, maybe I should do that, but I take the legislature for, you know, give the statute its plain meaning, and I would rely on the attorneys as officers of the court to make presentations to me as the trier of fact as far as what the evidence is going to show. And that's what a proffer is. It's a summary of what you believe a witness is going to testify or a document is going to show. And I think one of the pitfalls of non-binding arbitration from a cost effectiveness standpoint is it devolves into, you know, basically a second trial. You know, I will get like 10 binders full of evidentiary submissions that parties are going to submit a trial. It's fine and good. But frankly, that just generates, you know, if you submit it to an arbitrator, the arbitrator is going to have to review it. That's going to drive the cost of the arbitration process up. It seems to me that the better practice, and I know there's differences of opinion, is to summarize what the evidence will show. You know, that's just my take.
Given that then, George, do you interpret the informal proffers versus record evidence and affidavits with different weight, in the sense that if somebody elects to give a proffer and someone else is reading a true transcript, do you change your analysis and your credibility weighing on those?
You know, candidly, I don't. I'm for them the same way. I know that you know, it's would appear to, I guess, the way you've phrased your leading question, I would have to say, yeah, oh yes, I give it a different way. But I don't really think that I do. I rely upon the attorneys to proffer what is record-based evidence. Okay, I rely on them as officers of the court. There's nothing to prevent the opposing party from proffering, you know, a cross-examination as to what will be elicited on cross-examination from the same witness. You know, and then it devolves into, if they're diametrically opposed, then I would have to say that I would give weight to, you know, to any type of deposition site or something of that nature.
Yeah, my question wasn't intended to be leading. It's just important to know these best practices, because as we do with every judge, we always kind of tailor our presentations the way in which the arbitrator wants to receive that information. So if it is as you've indicated, cost effective for the client to not have a lawyer sit hours and present you lengthy deposition summaries and affidavits of witnesses, and you will take a proffer the same as sworn testimony, then that's important to know for the collective group that is on here.
And Kara, if I can just weigh in a little bit, keep in mind, George and Steve, I obviously echo their sentiments, but just reviewing the statute 44.1034 and its contemporaneous rule that talks about the informality of the hearing and presentation of testimonies to be kept to a minimum, I don't think you're going to see the word proffer listed in either the rule or the statute. So when I think of proffer, I think of it in the usual sense where you're in front of a judge or a jury, you want to proffer some testimony because there's objection to it and it's possibility it may be excluded. So you want to proffer it outside the presence of the jury. So I kind of view proffers in two senses. One, a proffer based on documented of record evidence, either by virtue of a document that's been produced, a request for admission, an interrogatory answer, or sworn deposition testimony, an affidavit, an acknowledged expert report or opinion, versus the proffer, kind of what George is talking about, of witness X is going to testify to Y. Now, as long as that witness has been a disclosed witness and it's not a witness that's surprise, I'm going to give it the same weight. But, you know, a lot of the questions that I see, or a lot of the topics we're going to discuss on the outline, are going to dovetail into some other arenas. So it really all depends upon what information has been exchanged. Have proffers or documents been exchanged 10 days before, like the orders of referral contemplate, or have they been exchanged the day of or not at all? And then is some of this complete element of surprise or arbitration by ambush? So I'm not necessarily going to give a different weight, but certainly if you can give me something with a record citation, obviously we will read that, we will check the citation. But yeah, I have literally, I could show you throughout this office right here, binders and binders of documents, because some of the cases I get appointed to, it just is the nature. There's complaints, counterclaims, cross claims, third-party complaints, especially in the construction defect arena. So binders are just going to be a part of it. But I kind of reviewed, proffers in the context of this statute, and the rule is kind of two different ones: actual record citations, and then what a witness that has not yet been deposed is really going to testify to. And we're certainly going to take you all as officers for the court that that's what the witness will testify to.
And I think that's a really good point, Berk, when you bring up the fact that the orders state that the parties shall, exchange their proffers 10 days before. Let's kind of shift gears and talk about the pre-arbitration submissions. In most of the arbitrations that I've been a part of, the arbitrators expect some sort of arbitration statement, as well as an exchange of the documents upon which the parties are going to rely. Can each of you speak a little bit? I'm confident you've all seen one or two arbitration statements in your day. What's a good arbitration statement look like? And specifically, what kind of content are you looking for? Are you looking for the party to present their entire case in that arbitration statement? Are you just looking for kind of an overview of the facts with the law applied to the facts? What are some of the effective methods you've seen of presenting arbitration statements?
So Joel, if I can, this is a very good question, interesting question, because, and I'm glad I see Judge Bocelli here. I have on my other screen here, I downloaded I found this on the 20th Judicial Circuit website, the most recent order of referral to non-binding arbitration that everyone's probably very familiar with. Within that, this emanates from an administrative order that was entered years ago by Judge Rossman, I think back in 2013. And it provides, there's some key language in here that I think that we need to probably delve into. It provides the parties shall submit case summaries. Okay, that phraseology is used. Case summaries to each arbitrator at least 10 days prior to the hearing. Now, I have clearly had people take that literally and present a case summary, copy it to the other side, and it's precisely that, a short, concise summary of their position. It does not contain record citations like a full-blown, what I would call arbitration statement and or trial brief, if you will. So I think there is a difference in the verbiage that's used here, case summary versus arbitration statement. And again, back to one of the points I just alluded to, when a full-blown arbitration statement replete with case citations, record citations to evidence is provided the day of or a day before an arbitration hearing, which candidly is pretty commonplace, that's going to typically, depending on the complexity of the case, is going to typically lead to requests from one side to keep the hearing open, to be able to respond to it in a reply or a rebuttal, which frankly, I don't think arbitrators are very fond of doing. I will do it if it is truly something that was provided the morning of, for instance, and there just hasn't been ample time to review it and respond to it. So I think what's contemplated by the order of referral, the case summary, may not be actually the same as what I am getting a day or two before as far as the full-blown arbitration statement.
I don't think it's a one-size-fits-all answer either. I mean, there are cases where you can give an arbitrator a very brief case summary and it doesn't involve any highly complex legal issues or anything, and it's really a fact-driven case. And that doesn't need as much. But if you're gonna argue all sorts of unique inferences and exceptions to exceptions under the law and everything, then you should be providing more of the case law and a legal memo along with it. But it's a case-by-case approach. And it's interesting to hear Berk say that arbitrators are not fond of keeping the arbitration open, because before I ever started mediating or arbitrating and I was a practitioner, I hated when the arbitration would be kept open. Was okay, what's he going to send to the arbitrator next week? And then I'm going to send something in response to that. And then he's going to send something. When does it stop? But it seemed to me that every arbitrator I went in front of did that. Said, okay, thank you for your submissions, and I'll give you each 5 days to send me anything else you want me to consider before. I despise that as a practitioner. So as an arbitrator, I do not, as a rule, leave it open. And the only exception to that is when somebody files something at the last minute, like Berk was describing, and you have to be fair. And I hate leaving it open. Because at some point the evidence has to close, and it's time to call the question. So I'm curious if George feels the same way.
My pet peeve, I do. I don't like keeping arbitrations open. I think that's counterproductive to the process. But really, a pet peeve of mine, I'm sure it is of the other arbitrators, is someone delivers to you 2 days before, doesn't read the order, delivers to you 2 days before the arbitration, 10 or 17 binders, and in a brief that is like the Gutenberg Bible. That is totally ineffective advocacy. What I think is effective advocacy is, at least in an arbitration context, is to give the arbitrator the nucleus of the case. There are 1,000 issues, but we as attorneys can cut it down to its bare essence. And I think less is better. Okay, I think it causes you as a practitioner to think about your case, to sculpture your presentation so that it's effective and cost effective, both cost effective and time efficient for all concerned. And I think many times I think everybody throws in the kitchen sink, and I'm guilty of it as well as a practitioner, because you don't want to not put something in that might have some impact on the decision maker, but really and truly the effective arbitration practitioners don't do that. They focus on the kernel of the case, and they emphasize the evidence that's really going to turn the issue. And that to me is just extremely effective.
George, I think you just answered my follow-up question as well. We were talking about arbitration statements, but is the same true for exhibits? Is it more effective to really kind of whittle down the universe of documents and focus on the ones that you think are most important for the arbitrator to review?
From my perspective, it is. If you're arbitrating a condominium dispute, and the declarations, is kind of a ancillary. I don't know how you would have this, but an ancillary issue. Just why are you pushing the entire declaration into the record as opposed to just emphasizing the provision? Naturally, if it refers to other provisions, you would want to do that. Your opponent can clearly make those presentations, but I think the more you can craft or tailor the presentation to the arbitrator, the more effective.
I think from a practitioner's perspective, I often hear people do not want to provide so much information in their pre-arbitration submittal. So it gives the other side an opportunity to kind of either wake themselves up to issues in a case that they weren't expecting, or give them time to address it at the non-binding arbitration. So there's this tactical gamesmanship that is essentially being played with the summaries and the exhibits leading into the actual non-binding arbitration, given the fact that it's exchanged, through everybody. But yet it's all going to come out at the non-binding arbitration anyways. But from a defendant's perspective, I often hear, well, I wait to see what the plaintiff actually proffers. And if they don't proffer an element of their damage, or if they don't proffer an issue with respect to liability, then I can really bring that issue up in my presentation that's happening right then and there. But essentially what I'm hearing is regardless of these kind of tactical plays that one may wish they are exploring, it sounds like if you're bringing them up at the actual non-binding arbitration, but for the first time, you're going to leave the issue open to have it briefed by the other side, and you're going to allow it to remain open to have maybe exchange of exhibits that may counter that, or deposition transcripts that may counter that. There's not an opportunity for this involuntary dismissal type of position. Is that what I'm hearing from everyone collectively? So maybe we can kind of eliminate this defendant's game or plaintiff's game of cross claims and counterclaim issues that happen, because it's all going to remain open and you're all going to get to the merits of it regardless. Is that what I'm hearing?
Yes. And
Okay.
keep in mind, it can remain open, I believe, under the rule for 30 days, which means 30 days from when the hearing commences. So at some point, absent court order, we have to cut it off. So please keep that in mind too when we request post-hearing briefs on certain issues. And yes, to Steve's point, to where we inject new issues post-hearing and we go back and forth, at some point it needs to stop, because we just don't have time within the confines that we're dealt with we want to be as flexible as we can. For instance, I no longer litigate. Okay. I'm 100% ADR practitioner, but I'm not that far removed from being a lawyer and a trial lawyer to realize things happen, things come up, and we need time. But if it's fresh on our mind, we really like to close out the hearing, I think, the day that we conduct the hearing, and that triggers our commencement of our 10 days to render our decision. So.
Well, and that raises two interesting points, I think. The first is, I try to always schedule a pre-arbitration conference about 2 weeks before the arbitration, and it only takes 15 or 20 minutes. It's normally very easy, and with Zoom and everything, it's so easy to do. And that does a couple of things. A, it reminds everybody you have this arbitration coming up in 2 weeks, so you should be giving the submittals because you should be giving them 10 days in advance. But it also gives you an opportunity to tell them, look, at the end of the close of the evidence, you know, I'm going to close it. I'm not going to leave it open. I want y'all to know that. But the flip side of that is everybody gets at least one swing of the bat. But that doesn't mean you get 2 swings of the bat. So somebody pulls a surprise, you know, at the last minute and files something the day before, you're going to leave it open to give the other side a shot at responding to that. But what I've seen some practitioners do is they show up with an expert's report, for instance, an expert's report on damages. And I recall a case in particular where the damages were based on a realtor's lost business, and the expert witness had used all the statistics for Lee and Cuyahoga County to demonstrate how much business this guy lost because he had a percentage of all of the business in the county. And it was clearly, the other side argued that it was way too speculative, that it wasn't appropriate, that this particular realtor didn't even do any work in Cuyahoga County. So why? That his entire market was in 2 communities in Lee County, but they had no expert report on the sales in those 2 communities. So they didn't have any damage evidence. And so they said, well, you're going to keep it open afterwards so that we can go have our expert write a new report just on those 2 communities. No, you got your swing at the bat. You came in, you put an expert report up, and the fact that it became obvious to you that it had no credibility during the course of the hearing isn't going to get you another swing at the bat, if that makes sense. So there's, I think both those points are important to make. Get the stuff in early and be prepared to close. And if you fail to present a point of your case, that doesn't give you the right to ask to keep the evidence open because you didn't do it.
That's really
Anybody else?
fascinating. One of the other things that comes up quite a bit is the use of live witness testimony. And some lawyers like to use it. I'd be interested to hear each of your perspectives on whether or not live witness testimony should be used. And if the answer is yes, what are the specific circumstances under which it would be appropriate? Because I understand it happens pretty infrequently, but are there circumstances where it would be appropriate to actually proffer live witness testimony at a non-binding arbitration?
I mean, so Joel, obviously the rule and statute contemplate is to be kept to a minimum. To me, if we're preaching, please try to do your homework, exchange your witnesses, your exhibits in advance, so there's really no arbitration by ambush, to be prepared, free flow of exchange of information, even a pre-arbitration conference, which I try and recommend to people to try to set up with me. Some take me up on it, some don't. In fact, the vast majority of them, I don't have any sort of pre-arbitration conference. But I would think that live witness testimony, I tell people that the rule obviously contemplates keep it to a minimum, and please try to do that. But there may be a circumstance where a party has not been, and/or key witness has not yet been deposed, and we want to hear from that individual because that person is crucial, and for whatever reason, they have not been available. That would be one exception where if it's a party and/or a material witness or an eyewitness, and I don't have anything else other than a proffer as to what this person may testify to, and that person is available, especially if it's a party and for whatever reason they've not been deposed, I want to hear from that person probably. So yes, that would be a limited circumstance where I would want to potentially hear live witness testimony.
Do you ask to hear the live witness? Meaning, do you say, I'd like to ask you a few questions?
If you all have arbitrated with me, I do a lot of homework in advance, and I'm going to interrupt you. I just am, whether it's during your proffer presentation, your argument section. So yes, if they call a witness, I will pick up with some of my own questions. Maybe it's just I haven't completely rid myself of the attorney in me that I just can't help myself. But yes, I'll chime in and ask a few questions if the attorneys don't get what I want to hear or there's a point that I want clarification on.
Why would any practitioner ever subject themselves to calling one of their witnesses to a non-binding arbitration? I mean,
Good
what
point.
tactically, what do you gain? And you know, it goes back to Steve Blount's pre-arbitration. I think that's a great practice, Steve, to have a pre-arbitration conference, and one that, you know, frankly, I fall into Berk's category. I don't do it enough, but I think it's the right thing to do. But, you know, if you're going to have live witnesses, it's time for the stenographer to show up too. You know, I mean, so, you know, why would you ever give someone a second bite at of the apple and have a transcript that can be used, because it's not a confidential proceeding, right? So it's fair game to use that as a sworn statement subsequently. Why would you ever do that?
So then the question is posed, do you allow the other side to call the party opponent if they choose to call the party opponent as their witness? So as the arbitrator, you would say, let's say, for example, plaintiff didn't call, or plaintiff's counsel didn't call plaintiff, but can defendant's counsel call plaintiff as their live witness?
They can proffer what they think that witness is going to testify to, but I would not permit them to call an adverse witness at a non-binding arbitration proceeding.
Yeah, why would they want to do that? Why wouldn't they just proffer what they would, you know, proffer the perfect cross?
Right.
But there's only two circumstances where I ever see live witnesses called. One is in a very simple case where it's a he said, she said, and they really want you to be able to judge the credibility of the parties. And it's literally, they're going to call the plaintiff and they're going to call the defendant, and each one's going to essentially tell their story. But the other scenario is in construction defect cases where they want to call the expert live because of the technical nature of their testimony. They think they're more effective at explaining what their report says than the lawyers would be. And those are the only two scenarios where I ever see it.
In those scenarios where live witness testimony is provided at the arbitration proceeding, I guess I'll ask two questions. A, do you permit cross-examination of that witness? And B, do the parties even usually take you up on it if you do during the arbitration?
Yes.
Yes and yes.
Okay.
Yes, and sometimes if they're prepared, but typically it would be yes and yes.
Does that tend to elicit objections to the questioning, and how do you all handle that in terms of the parties are asking questions? Are objections raised? Do you treat it like a normal court proceeding and make those types of ruling like a sitting judge would at an arbitration proceeding?
I don't, because it's supposed to be informal.
I normally don't, and I usually will tell counsel, hold your objections, and if you hear anything that was objectionable or you would have objected to, tell me after the fact. Don't interrupt them. Let's keep it flowing, because I'm capable of hearing something and then saying, oh, that was objected to and that objection would be sustained, so I'm not going to consider that, or that, you know, that's easy to do. So I'd rather hear it and then dismiss it in my mind than go through a bunch of temporal objections the whole time.
Agreed.
So we're all currently on a Zoom. We're kind of all living in a post-COVID world where a lot of things are being done via Zoom. Are each of you seeing any sort of trends in terms of the number of in-person arbitration proceedings you're seeing versus the number of Zoom arbitrations you're seeing? And are you seeing any sort of discernible difference between in-person arbitrations and Zoom proceedings?
My experience has been the larger cases tend to be in person, and the smaller cases tend to be in, by Zoom. But I think most of my arbitrations are by Zoom. I don't know what everyone else's experience is.
Most of mine are by Zoom, and I actually like them being by Zoom. It gives me the ability to, as you know, people share screen, but what I do is I pull up the exhibit that they've got on their screen. I pull up on the next screen in my, so I'm not looking at the screen anymore. I'm looking at mine, and I'm able to take notes on it. And I'm able to, you know, while the testimony is going on, and I'm able to type it in and everything. It's a lot easier. If you have handwriting like mine, which I can't even read sometimes, it's easier that way. So I like the Zoom arbitrations. It makes it real easy to electronically say. I don't have notebooks stacked on my desk because all the documents come electronically. I can make my notes electronically. I can save it all electronically. I can even start writing portions of my decision, you know, while the thing is going on.
Yeah, vast. I echo Steve and George. The vast majority are still being conducted via Zoom. I don't preclude in person. I would welcome in-person arbitrations. The ones that are in person are, like George said, are generally of a much larger context, multi-party. It's not, and I agree with Steve, the technology on Zoom by share screen, dropping documents in the chat. If you're proficient at it, it can go very smoothly. If you're not, it can be a quagmire and a mess. But still, I get it. There's people that want to, on these larger cases, where the issues are somewhat complex, construction defect, for instance, where they want to conduct in person, then let's do it. But yeah, the vast majority, Zoom is here to stay, or the equivalent. It's not going away in the ADR world, whether we're talking mediations or arbitrations.
I still have a physical office with 3 conference rooms in addition to my office, but I don't think beyond next year I'm going to have that anymore because it's just nobody uses it anymore.
So that brings us to kind of this next topic, which is professionalism, both via Zoom and in person, that should transcend regardless of the medium. But I think one of the things that we are seeing in this process is that individuals, because of the informality of it all, tend to forget that this is an actual proceeding. And it is intended to somewhat be a proceeding, although under the cloak of an ADR. And I know recently I've had a circumstance with Berk, I won't get into it in detail, but where someone believed that they were muted. They were not muted, and they made several very derogatory statements, despite the screaming through the microphone to say, "You're not muted, stop saying the very inappropriate statements that were being made." That was before that was during a break, and I can't help but think that shifted the way in which everybody conducted themselves for the remainder of the remainder of the non-binding arbitration. Certainly, it made it far more contentious than it needed to be, just given the off-camera, off-mute statements that were made. But are you seeing that people are treating this process with the same level of professionalism that they should? Or is it still becoming a very informal process where professionalism has sometimes slipped?
It slips at times, in part because we don't, in my estimation, because we don't wear a robe. Okay, we are not judges. Now, I think that's the minority of the cases, the vast minority, but it clearly happens where I simply cannot rein in parties, although I try, and I arbitrate cases all over the state of Florida now, especially first party related cases. Some lawyers, I mean, obviously lawyers that practice here in the 20th are certainly They deal with this on a daily or if not weekly basis. Practitioners outside of our circuit, some have never handled a non-binding arbitration before because their circuits just don't refer cases to non-binding arbitration. But the fact that we don't wear robes, although we try to keep it obviously informal, but also formal at the same time, because we need it to be conducted in a professional manner where people aren't talking over each other. And keep in mind, folks, it's our objective to give you the best evaluative opinion that we can. We understand that someone's going to disagree. We understand that someone is going to reject our award. But I think if you ask the judges, that it's not the hopes that someone doesn't accept our award and our award becomes final. It's the hopes that our award gives you the benefit of evaluative decision. And I would think that you ask the judges that one of the reasons this continues to get ordered is that cases tend to settle more likely than not after the receipt of an independent third-party evaluation vis-a-vis an arbitration decision. Look, the vast majority of arbitrations, people know me. They come in, they act professional, but there are still cases where regardless of the situation, because it is informal and because we are not the judiciary, some people take advantage and simply can't control themselves, unfortunately. It happens. It just does. It's rare, but it happens.
George, Steve?
Extremely rare. Almost never.
My experience has been the most, and my arbitration practices primarily within the 20th. I find that the practitioners, by the vast majority, have been extremely professional fashion in arbitration.
Positive news. So moving on, because we only have about 13 minutes left, and I did want to touch on two really important issues, one in which being the rule change. I've raised this in the outline, and I raised this to Joel's attention because despite the rule having changed in July, it came on my radar after I observed a $39 million construction lien being discharged from someone not complying with the rule that requires you to issue a rejection and a request for trial de novo pursuant to Rule 1.820's amendment in the same pleading. And Judge Foster said that it's a shall in the statute, and so he's going to follow the rule. And based upon the rule requirement, the arbitration award was unsealed sua sponte, and case resolved in that manner, which has now sent a ripple effect around the 20th, I believe, just given the nature of the monetary award. So I say all that to say, are you seeing people unfamiliar with the new requirements and simply just filing a motion for trial de novo without that notice of rejection of the arbitrations award? And are any of the people coming back to you and having requests to clarify your awards in light of the fact that this requirement is so stringent at this point?
Yes.
Motions for clarification or
No,
motion?
I have had two circumstances where during the 20 days, motions entitled motions for trial de novo have been filed, where the parties continue to go about their business, because I don't deselect myself from service. I probably should, because my inbox just gets littered with information, but where the parties continue to litigate, take depositions, exchange information, and then sua sponte, I've had two judges say, wait a minute, I went back and looked in the record. There was not a motion or a rejection under the new rule using the new rule language and the shall. I direct either sua sponte, the clerk, to unseal it, or I direct the plaintiff or one of the parties to file a motion to unseal. And I've had that happen on two circumstances. So yes, everyone's antenna need to be up. Look at Rule 1.820H. It's effective July 1 of 2024. I myself personally have noticed that if you look at the rule language, 1.820H, the word trial de novo is no longer used in that rule. It is a notice of rejection. What hasn't happened, though, is the legislature has not yet amended Florida Statute 44.1035. You will still find a request for trial de novo language in rule in Section 5 of that statute. You will still find it in our orders of referral to non-binding arbitration in our circuit. So I do think our order of referral needs to be updated in our circuit because it is referring to Rule 1.820H in its prior context. But there is a difference between the statutory language, which still calls for a trial de novo, and the rule, which I think the legislature needs to step in and clarify that, because one of the circumstances that Kara mentioned, that is the argument that is being presented, is that, well, we did exactly what the local order of referral said, the local administrative order said, and what 44.1035 says. And notwithstanding, that is now a case where it is possibly going to go up on appeal. So regardless of all that, though, be aware of the rule, be aware of the language, create a new template for everything post July 1, 2024.
Great advice.
I haven't seen it become much of an issue yet, but that may be in part because I do a lot of hybrid arbitrations. And I noticed that's something on the outline that we hopped over a little bit. I do a lot of arbitrations where I'll do an arbitration in the morning, and once the arbitration concludes, I take a 15-minute break and go jot down the essential elements of what my decision is, and I put it in the drawer, and then we go mediate. And I find that to be an incredibly effective process, so effective that I think I can't think of one that didn't settle in the last 2 years. I mean, and that's a lot of proceedings. And so we don't get to that place where a decision is made, even though we started out arbitrating. And that's one of those things that's discussed in that pre-arbitration hearing. Hey, are we just going to do an arbitration, or are we going to do a hybrid? Because as the arbitration process goes on and they hear the questions that come from the arbitrator invariably, and they hear the other side's case, and they hear in concrete terms how things are going to be presented through the proffer. We're going to show this document, this witness is going to say this witness is going to say that. After the parties have heard all that, when they attended an arbitration, boy, the mediation can go quick and can be much more effective, because people just saw the other side's presentation. I mean, how many of us as mediators have said in our opening statements, listen very closely to the argument presented by the opposing lawyer. This is the one time that the opposing lawyer gets to talk to the opposing party directly. And consider the possibility that somebody might accept their argument, in a mediation. When in arbitration, they essentially heard a very detailed, very thorough presentation of the other side's argument in very concrete terms. And once the other party has seen that, it has an incredible effect on their willingness to compromise. And so I think the hybrid arbitration, then mediation, never the other way around, is extremely effective. I mean, extremely. I can't say that in strong enough terms.
Since we hopped over that, but Steve's given a really great analysis on it, does George and Berk, do either of you do hybrids? Do you find that there's any issues with that, both from when you practiced or now as the arbitrator?
I do hybrids, and I do them the same way that Steve's proposing, arbitration mediation as opposed to mediation arbitration. I agree with them 100% that mediation arbitration is fraught with all sorts of pitfalls, which we don't need to go into in detail. Compromising impartiality, basically running contrary to the concept of empowering the parties to make their own decision. There's just a number of reasons why you don't want to do a mediation arbitration. But an arbitration mediation is an effective process. I do think you need that hiatus between the arbitration and the mediation where you can put down your thoughts as far as the arbitration award. I think the arbitration award has to be, you have to get the parties to agree that the arbitration award will be minimal in nature, not, recite the evidence, but basically it's proffered, but very minimalistic, but I think it's very effective.
Yeah, no, I concur with both Steve and George. The ARB mead is effective. The case gets laid out. You don't get a chance to mediate cases that often after essentially an evidentiary presentation. So it definitely has that effect. I, however, do see a lot of the attorneys requesting to do the mediation first. I don't know if it's they just hope they don't have to dovetail into a mediation, or excuse me, an arbitration, and be prepared to present a full-blown arbitration. I absolutely concur with George that if the limited occasions where I've done ARBs, mediations first and then arbitrations, it's just because the lawyers have requested that I do it that way. I have the same reluctancies based on the same issues that George raised. We wear two different hats, folks, when we mediate and then when we arbitrate. But I understand that people hope that we settle so we don't have to do the arbitration. But I'd much prefer to do it the other way around, the other way as for the precise reasons that George and Steve. It's effective. And I think it's just from a practical standpoint, it's the best way ethically to do it.
From one final question on this particular process, and then we'll wrap up since I know Steve has to leave early, or at least leave right on time. When we are doing these hybrids and we do an arbitration first and a mediation second, and maybe there's the 15-30 minute, whatever the circumstances are, break in the middle, does that have you all change the way in which you receive and or get yourself involved in the arbitration process? Do you ask more questions? Do you press issues or legal arguments more in the arbitration process to help dovetail what you intend on doing in the mediation? Or do you treat them completely the same? Maybe you have a couple of pointing questions that you wish you would have asked maybe during the arbitration, but you hold them for the mediation.
I try to say less during the arbitration aspect if it's a mediation. While I typically am very involved, I am very concerned about asking a question that might tip my hand or might be perceived as tipping my hand. So I try to have less interaction with the presentations or the presenters during the arbitration aspect of it than I would in a normal arbitration.
Interesting.
I try to do the arbitration the same way I would always do the arbitration. The concern comes as you're mediating and you're in private caucus, you have to make it perfectly clear that if you make a comment in caucus and mediation, it should not be interpreted as having anything to do with what your arbitration decision that's sitting in the drawer was. Because you all, and I think I've worked with almost everybody that I see on the screen here, all the names, part of the way I work is to raise the opposing argument, playing the devil's advocate in the room when I'm in private caucus. And I have to make it doubly clear to them that that the law is gray and I'm making the counter argument. It doesn't have anything to do with what I did this morning in arbitration. And that's a little tricky sometimes. But like I said, I still think it's the most effective process there is.
Well, since we are short on time, does anyone have any kind of best practices, closing remarks, or things that we didn't touch on that you wish to share with the collective group, both here and ultimately recorded? No, we touched on pretty much everything.
Yeah, everything.
Thank you for the ad in the chat, Lauren.
Well, thank you all three of you for being willing to present today. I know Joel and I really appreciate your busy schedules and carving this time out. I know you probably have things to do. Yes, we will be doing another one of these and you'll get your CLE credits. I think Lauren passes all of that information out at the end. So anything else, Joel?
Thank you all so much for doing this. Again, everyone in here should be using Berk, Steve, and George for arbitrations. And if you're not, I think that by sitting in here today, you realize that you should be, because they're three of the best that we've got here in Southwest Florida.
Or maybe not, and Joel and I'll just keep using them so we can actually get on their calendars.
That's okay too.
Yes.
I'm off.
Thank you guys. I appreciate
Thanks,
your
everyone.
time.
Thank you, everybody.
Happy holidays, everyone. Bye-bye.
Thank you.